May I please your attention? My lord, 51. With regard to the item number 51, my lord.
51.
51. I have some difficulty in the second half, my lord. I am just mentioning this item with a prayer, my lord. In this case, my lord, already there is one more case, the criminal petition for the same cause of action against the same order, my lord, of taking cognizance, already been stayed by the coordinate bench, my lordship, in page number 85, my lord. In that case, my lord, stay has been granted by the coordinate bench, my lord, holding that this is a civil nature, my lord, dispute it, my lord. So that order also can be, my lord, passed in this order also. Page 85, my lord.
51.
Page 51.
No. Item 51.
Item 51, my lord. Page 85, my lord.
Okay.
Same order, my lord. TCR has already been received.
Page 85 is the
Yes,
order that you have annexed.
Yes. Co-accused order, my lord. Where stay has been operating, my lord.
51 to Matute to very good. Let it be called up in due course. We'll see at that time.
My lord.
Give you junior.
Yes. Obliged, my lord.
May it please, Your Honor. My lord, I beg to mention item number 46, my lord. My lord, in this criminal petition, relief sought by the petitioner already, my lord, meet, my lord. So,
Just 1 moment. এখন আছে দেখুন ইয়াতে নহলে একটু yes
item number 46, my lord. In this criminal petition, my lord, the petitioner bank account was freezed, my lord. Now,
petitioner
bank account, my lord, was freezed, my lord, due to a complaint by the cyber, my lord. And already, my lord, it is, my lord, opened by the bank. My learned friend also informed me.
They defreeze the account, my lord.
so withdraw
Wants to withdraw, my lord.
My lord, motion
All-
invited to
on the prayer of learned counsel for the petitioner Mr.
you, the lord.
Diuddin matter is dismissed as withdrawn.
My presence may be recorded, my lord.
Pursuant to appears for
Round number 3.
yes.
May I please, your lordship? I beg to mention item number 31. This matter may kindly be come up on 24, lordship. Postmortem report has not been received today.
All right, 31 on 24th.
31, 30%.
31.
Both.
Postmortem report has not been received.
All right, so but you're tied up with 32. You're not there in 32.
32, I'm not there, lordship.
Then how can you just mention one item when it's tied up? Does that counsel for the second item is not able there, he would not know. That is why. Okay, let it be adjourned, fixed on 24th when he comes with the price.
May it please your lordship. Lordship, with regards to item number 50 of the daily list, your lordship, I am being led by senior counsel Mr. K. N. Chaudhary. Lordship, he is indisposed today. I have informed the other side. Matter relates to quashing of an FIR against me, your lordship, as well as a charge sheet. There is stay in both the matters, your lordship.
All right, after vacation.
After. Lordship,
Give a
may kindly
date
fix
after
a date.
vacation.
Lordship, may kindly fix a date, your lordship.
Yes, give a date.
Lordship, interim orders may continue.
Interim order passed to continue.
Lordship, in item number 31, interim is there, lordship. Interim order.
All right, interim order.
Please, your lordship, I beg to mention item number 39 and 40. As CD has not yet been received.
Is they not received?
It said did not receive. Again on.
Also, your lordship, interim.
Yes. All right.
I beg to mention item number. Yeah, join for the.
1-5.
One count, Lordship. Is motion.
Vacation.
No, Lordship, can it be on next week, any date? Lord?
Already.
Obliged.
Please, Your Lordship. I beg to mention item number 43. Today we are seeking an adjournment, my lords, because my senior is not keeping well. Item will come up on the next week, my lords. We have received a case diary, retained the city. Case diary may be retained, my lords.
On the prayer of learned counsel for the petitioner, list again of
43.
be retained till then. Yes. Yes, next.
Next week, 24. My lords.
May it please your lordship, I beg to mention item number 37. CD is perhaps not there in this matter. I am on interim. 37.
Yes, they not. Interim.
My interim will be extended, Lord.
22nd of July.
Yes.
Deeply obliged.
May it please your lordship, I beg to mention item number 17, lordship. Kindly pass over the matter for the day. Kindly fix it and after vacation, lordship.
After vacation.
Much obliged.
Item number 1. In this case, your lordship, last occasion, your lordship has on Monday heard the matter and directed them to produce the case there, your lordship, but somehow that was not reflected in the order. Your lordship, I am seeking bail mainly on the medical ground, your lordship. Your lordship, if go through the FIR at page 17, your lordship.
Which station is this?
Lordship,
Which PS?
page 17 is the FIR, your lordship. Bilasipara PS, your lordship.
Bilasipara.
Bilasipara. Your lordship has, your lordship, Monday, having going through the affirmance, your lordship, and the submissions made on behalf of the petitioner has asked them to produce the case diary today, your lordship. Today is 27th day, your lordship. FIR is at page 17, your lordship. There are certain statements made by him, your lordship. Page 17 is the FIR.
Not called for.
My lord, since the matter has come in the motion column, my lord, and if there is no like order calling for the case diary, my lord, the case diary is not, my lord.
Then maybe you have called for because as per practice, you note it down
Lordship,
when CD is
that
called.
is-
My lord, let it come on Monday, my lord. If the case diary is come, my lord, we'll produce on Monday, my lord.
Only difficulty is, your lordship, the medical condition. Your lordship may kindly, I have, on last occasion, your lordship has.
No, we want to know because they don't wait for to read our order when
Lordship.
CD is called for. They note it down and call for it. It may have come. Let them just check.
Lords.
Right, Monday. On the last, Mr. Surenso, on the last occasion, so CD was called for. The same is not reflected in the order dated 15/6/2026. We wanted additional PP. Take some time to confirm whether the CD has been called for and received from the office of the PP. Hence, list the matter again on Monday.
Obliged, your lord.
Even if it is not there, you can call, maybe it can come on Monday also.
Next time we'll call, man.
May it please your lordship, my lord, page 8 is the FIR, my lord. Allegation is, my lord, theft of, my lord, two numbers of cattle, my lord. And my lord, the co-accused has already been granted bail, my lord. I've annexed the order, my lord. The page 19 is the order of this honorable court, my lord.
Who's the other accused?
My lord, he's my lord,
Rahim
Rahim
Badsha.
Badsha, my lord, Rahim Badsha. On the basis, he was arrested, my lord. He was arrested on 25 and released on 27/5. And on the basis of his statement, we are arrested, my lord. That is the allegation. On the basis of his allegation, statement, we are arrested.
Page 15, forwarding report, these are the persons arrested.
Yeah, my lord, they decided a person arrested on 20/5. Number
Akir
two.
Abdullah, Maznur, Chan Mohammed, Khalifuddin
Yes,
and Mustafa.
Abdullah, my lord. Very unfortunate, my lord. His name is Abdullah, my lord.
No, no,
And-
present petitioner.
The President Abdullah Ali, my lord. And my lord, Rahim Badsha, my lord, on the basis of his statement, we are arrested. He was arrested, my lord, subsequently released on bail on. He was arrested 25 and released on 27/5.
Confession of Rahim Badsha, what is the confession?
My lord, my lord, Rahim Badsha, my lord, that is my lord, page 16, my lord, the first ground of
No,
arrest.
you are clearly visible on CCTV footage. As per forwarding report.
My lord, page 16, paragraph 1, my lord. Rahim Badsha, my lord, he was arrested.
You may be arrested on the basis of his statement, but subsequently there is other evidence. Not based solely on the statement of co-accused.
But considering the length of detention, my lord, almost a month, my lord, in jail, my lord. My lord, upcoming vacations, my lord.
What vacation?
1 month in jail, my lord. Co-accused has been granted bail, my lord.
Alright, 24 CD.
24 civil matters fixed, my lord. Can it be on 23rd, my lord?
23rd.
Obliged, my lord.
May I please your lordship? My lord, the petitioners already have been arrested, my lord, and petitioners here, my lord. Actual fact, my lord, there is a, my lord, dispute, my lord, for a plot of land, my lord. My lord, cross case also there, my lord, we filed, my lord, our FIR on 2/6, my lord, and they, my lord, filed on 3, my lord, next day, my lord. So their FIR, my lord, kindly turn to page 12, my lord. Is reflected in the FIR itself, my lord. Actually, my lord, they are trying to encroach our land, my lord. I have annexed the, my lord, register date also, my lord. Page 12. Their FIR, my lord. My lord, here, accused 2 and 6 have been arrested. Who were present in the place of occurrence.
When were you arrested?
My lord, arrested on my lord, 4/6, my lord. And kindly turn to page,
4/6.
our affair, my lord, page 32, which was lost earlier, my lord. As a counter blast, my lord, they filed there as a
32.
32, my lord.
Where is your form?
My lord.
Format starts at which page?
For my lord, page 36, my lord. Information received.
How can you say prior?
My lord, yes, my lord.
This is 2/6. Present
yes, my
FIR is 2/6.
Yes, my lord. Our
Yours
affair,
is
my lord.
8/6.
My lord, no 8/6, not my lord.
Eh?
2/6, my lord. Kindly serial number 3, my lord. Occurrence of my lord from 2/6 to then so my lord. Information received. Not 8, my lord. Kindly see our affair, my lord.
That is
Kindly turn.
occurrence.
Yes, my lord. But we filed, my lord, on 2, my lord.
Information received at PS 8626
But my lord,
2319
but my lord, we filed on
after
2,
6
my lord.
days.
My lord, kindly turn to page 33, my lord. Kindly turn to page 33, my lord. It was
Yes.
registered on that day, my lord, because after our case was registered later, my lord.
We are going by your own document.
Turn to page 33, my lord.
33 is the content
My
only.
lord. I have conducted inquiry into the matter because it was, my lord, under inquiry, my lord. That is why, my lord, our case was, my lord, registered later on, my lord. So we filed immediately, my lord, on 2, my lord. It was on inquiry, my lord. That is why, my lord, it was registered on 8, my lord. Because immediately we admitted into hospital, my lord. These petitioners were picked up from the hospital, my lord. From the Borpeta Medical College, my lord. It's a fact, my lord. We filed on 2.
And what happened to you in
My lord,
that affair?
My lord, our affair, my lord, it is under investigation, my lord. Kindly turn to page 25, my lord, sale deed, my lord. Because, my lord, we purchased our land, my lord, on 2018, my lord. But they are trying to encroach our, my lord, land, where it is, my lord, shop, my shop is, my lord, established, my lord. Page 25, my lord. Our, my lord, patta land, my lord, they are trying to encroach, my lord. Type page, my lord, page 25.
I have salaried and all that, whatever, but fact remains that as per forwarding report, it is you who trespassed into their land and caused
my lord, that
grievous
is
injuries.
not fair, my lord. Because, my lord, that is why, my lord, I have annexed the, my lord, sale deed, my lord. Because they are trying to, my lord, grab our land, my lord. Where, my lord, my shop is, earlier shop is established, my lord, since long. And I purchased the land, my lord, since in 2018, my lord.
Without knowing the
Anyway, my lord,
injuries.
both the parties, my lord, there was some assault, my lord,
Since when?
quarrel, my lord.
CD, my lord.
When?
But, my lord, kindly before vacation, my lord.
25 minutes.
Obliged.
I plead your lordship. Similar matter fixed on 25/6/2026.
Please take it along
DA
with.
number 1560 lordship. 1560
25,
along with 2026.
15.
1560. Fixed on 25th. I please lordship, regular bail application. Lordship, victim has already been recovered. Kindly may see page 19, lordship. Grounds of arrest, para 3. That on 21st May 2026, the accused person was apprehended and the victim girl was recovered from his possession, and his arrest was necessary for further investigation of the case. Lordship, I got ample time to investigate the case, Lordship. So kindly consider his bail. Today is 29 days behind the bar.
At this stage, my lord, CD may be called from my lord. Since my lord, as
Lordship,
per the
there
FIR,
was
my lord,
a-
let me something please. As per the FIR, my lord, victim was 17 years of age, my lord. Although as per the forwarding report, my lord, the victim has already been recovered, my lord, but her statement is necessary, my lord.
It may become POCSO also.
Yes, that is one. Also maybe added
Maybe
later on.
fix before vacation, Lordship, as of 26. Otherwise.
The matter may be passed over for some time.
May it please your Lordship, it's in bail application under 483 BNSS. The FIR vernacular is in page 16, Lordship. May I read? এজাহাৰকাৰী সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি ৰাতি প্ৰায় 9 মান বজাত মোৰ ল'ৰা অনুৰণ দাস 14 বছৰ ঘৰৰ বাহিৰত বাটত ৰৈ থকাত ময়ো বাহিৰত ওলাই আহি যদিও উক্ত পদকীয়া লগ পাওঁ পদকীয়াই মোৰ সন্তানৰ বিষয়ে বহুত বেয়াকৈ কয় তথাপিও মই পদকীয়াৰ বদ অভ্যাসৰ বডি লৈ ৰাখি মই একো কৰো যদিও কিছু সময় পিছত মই
ইংলিছখন নাই নেকি? ইংলিছখন পঢ়া।
The translated copy is in page 14, Lordship. With due respect, I, the informant, begs to state that tonight at about 9, while my son Anuran Das, 14 years, was standing in front of our house, I also came out of my residence and met the
It's
accused.
118 grievous injury.
Grievous
You see the
injury.
CD.
The matter may be fixed before vacation, Lordship. Obliged.
Please, your Lordship. We had this case, Lordship, the petitioner is a higher secondary teacher, Lordship. And some dispute altercation took place between his younger brother's sons and the petitioner's sons, Lordship. On 18/5/2026 regarding, Lordship, domestic issue, Lordship, and Idul Adha, Lordship, and some sacrifice, Lordship. In this regard, Lordship, the government pronounced some SOP, Lordship. The petitioner younger brother, Lordship, and he disobeyed this. And subsequently, Lordship, and some argument took place in the morning hour, Lordship. At night 11 p.m, Lordship, my son and my younger brother's son, Lordship, some dispute is there, Lordship. And subsequently, Lordship, an FIR has been lodged on next day, Lordship, and my name is also projected in this FIR, Lordship. So I am in custody, Lordship, as on today, 20 days. Lordship, FIR will file, Lordship, and come to page number 12, Lordship. A translated copy, Lordship. My lord, in this case, Lordship, my involvement is totally not there, Lordship. Only, Lordship, my name is projected in the FIR last number, Lordship. But I am being this higher secondary teacher, Lordship, government employee. And then come to, Lordship, my identity card is page number 22, Lordship. Regarding the sacrifice of the Idul Adha, Lordship, my involvement is not there, Lordship, at all. But it is admitted, my son and my younger brother, we are residing in the same house, Lordship, same residential premises.
You have been squarely named. What is?
Lastly, Lordship, my name is projected, but otherwise, Lordship, I am this last few months after, Lordship, I'll be retired, Lordship, from the service, Lordship. But
You are already arrested.
Lordship.
What is the? This is not an AV. Yes.
Update lordship before vacation.
25, my lord.
Deeply obliged, deeply obliged.
Item number 9.
A report was called for regarding the any cases registered against the petitioner. or-
Lordship, kindly matter may pass over for some time.
We have not received the report. Lordship. Another we have to call it.
Okay. Sometime.
Item number 10. There was a matter we passed over for the time being. Contracting council. Item number 11.
Please, your lordship. What is the for 82 applications, my lord, in the secretary bail, my lord. The allegations in the FIR, my lord, that FIR lordship will find at page, my lord, 10, my lord, is basically theft of a diesel, my lord, from the truck of the informants, my lord. So on the same night, my lord, so 3 informant has described, they have not seen the incident, but they have simply stated that there was a theft of the diesel, my lord. At the last paragraph, page 12, my lord, there is a on 14th on the next day, my lord, on 14/5, after receiving the message through sources, we all the informant discuss about the incident, and in front of the shop of so and so, the accused number 4 admitted and stated the name of other 3 accused person in presence of assembled person. Accused number 4 also admitted that the stolen goods were stolen to so and so or sold to so and so, and all statements were admitted in presence of other peoples, my lord. So, my lord, this is, my lord, the accused number 4, my lord. I am not accused number 4, my lord. So, accused number 4 has admitted, my lord, that there was stolen of the theft of that diesel, my lord, and he named the name of, my lord, for 3 persons, my lord, including me, my lord. So, my lord, actually, what has happened on that day when there was a gathering, my lord, we are also there. It is basically all people's informants and the accused, they are from the same village, my lord. And the petitioner, my lord, has made a strong remark that regarding that negligence in handling their vehicles, my lord, because of which, my lord, that incident happened, my lord. So, my lord, accused number name has been indicated, my lord, in the FIR, my lord. Otherwise, he is not involved, my lord, with the theft, my lord.
In the FIR, his name is specifically named. Lordship.
Vehicle drivers, my lord, they were not there. Has not seen the incidents.
What is this? Sir?
Yes, my
Who is
lord.
acting this?
My lord, this is how the affair has been drafted by 3 informants, my lord, together, my lord.
All right, CD.
My lord. My lord, may I pray, my lord, this be granted, my lord, because I will cooperate with the investigations, my lord. I will just record my statement, my lord.
We'll be lucky if after seeing the CD we grant it.
And my lord, the before vacations, my lord, any date, my lord.
I don't think we can accommodate so many things before vacation. I think already lists are full.
My lord. On 24th, my lord.
No point. On reopening.
14, 14 seconds.
14th, my lord. Oblige, my lord.
May I please also for 82 application also, offense is 69 of the BNS. FIR also will find it page 15. Actually, they had love affairs also. Main problem started when the parents of the petitioner objected to their relations. That you'll also find in page 15. The lower portion I'll read, Lordship. I was physically abused by the parents of the accused person. He also tortured me. I was tortured till 21/6/26. So on 9, the day after, she filed the FIR. And so far petitioner is concerned, he is a government servant. She is also major, he is also major. Basically, the parents objected to their relationship. After 20 days, the FIR was filed.
Can be qualified along with the victim statement also.
In the meantime, loss will protect me. It's from Lakhimpur. The government servant.
Original is 21.
That's it. FIR was lodged on 9/6. It should have been 21/5. This is written in the FIR is 21/6. It ought to have been 21/5/26. He left my home.
Originally 21.
They have been 21/5. The FIR was lodged after 20 days on 9/6/26. Basically, she was not accepted by the parents. That's why she was filed there.
So if she was in love with you, why did she vent your ire on you instead of the parents? huh?
He locked it me. That's why. There's scope of conciliation is also there.
The age of the victim?
Victim is 21, he is 25.
Let counsel for the petitioner. Raise an application under so and so. Perusal of the FIR transpire that the victim was in love affair with the accused petitioner and eloped with him, but she was not accepted by her parents, by the parents of the petitioner. Thereafter, the accused took her to another place where he committed forcible sexual intercourse with her and also tortured her. Learned Mr. Senior Counsel submits that FIR has been lodged because the parents of the petitioner did not accept her. The same has been lodged. How many days?
After 20 days.
20 days after the alleged occurrence. There are call for the CD. In the interim, it is provided that one surety. Try to influence the witness. List on.
July.
Much.
Yeah, please. Petitioners, my lord, are officers of the United Insurance Company. So the informant was empaneled as an advocate, my lord. Now, my lord, there was a delay in, my lord, getting the, my lord,
Not in LIC.
My lord?
Not in LIC.
Not in LIC, my lord. United Insurance Company, my lord. It was a, my lord, there was delay in allotment of the resource code, my lord. For that, he could not be allotted cases. Well, and he initially filed an RTI application asking for information about other advocate, how many cases have been allotted to them, etc., etc. Well, then he lodges this FIR, alleging that indirectly these officers asked him bribe to issue the advocate code. Well, the advocate code I have annexed, my lord. It took about 1 year to generate, my lord. It's only been the illicit cases, my lord. He has, my lord, kind of frustrated, perhaps, my lord, because it was getting delayed. And my lord, Lordship will see paragraph 2 of my lord, page 17. Lord, he said indirectly they asked him bribe from him, my lord. He was called to his office, their office, my lord, handed over the appointment letter. And then, my lord, there was a delay because citing some it was indeed some technical difficulty, my lord, for which they could not issue the advocate's code number. And then he waited for a few months on an unspecific date. He says that indirectly he was asked for favor, bribe to issue his advocate code and allot case numbers. And pursuant to his RTI application, my lord, when the names of advocates were furnished, his name could not be furnished because of the non-available resource code. So he came to a conclusion that his appointment letter is fake.
According to you, appointment letter is genuine.
The resource code also, it took some time to generate the resource code. Page 34, madam. I have annexed that also. That is done by the head office, not by the regional office. The appointment is by the regional office, madam. That also I have annexed page 32, madam. That here, this because how can an officer of the United with the insurance company, my lord, allot cases to a fake advocate, my lord, fake, my lord, empaneled advocate?
They cannot, my lord. They'll be liable for disciplinary proceeding. It was issued by the regional office, my lord. Lordship will see page 33. It's signed by the chief regional officer, manager. And page 34, my lord, resource, my lord, code was generated by the head office, my lord. Administrative officer, IT department, head office, Chennai. So it took some time, my lord. It took almost 1 year. That's correct. But then, my lord, Lordship will see that it says RTI application is page 30. Nothing about his, my lord, enrollment, etc. He says how many advocates have been given case in the last 10 years. He was, my lord, allotted, my lord, empaneled in 2024, page 30, my lord. Details of total number of advocates presently empaneled in a company, also actively working in your company, for lower courts, MSCT courts, etc. Details of total number of cases allotted to the empaneled advocates during last 10 years. He was only empaneled in 2024. Names of advocates together with case numbers allotted to the individual and specifically mention the court numbers so and so, so and so. Details of total numbers of advocates presently empaneled appointed in a company for the district of Kamrup Metro for the month of January 2024 till date. Kindly furnish the names of advocates, date of appointment, total number of cases allotted, date of allotment of cases, etc. With his RTI application, nowhere my lord seeks his, my lord, enrollment number, etc. or why there is a delay in his issuing the resource code. And my lord, then he comes to a conclusion at page 18, my lord, of the FIR, page 2. Paragraph 2. In my reply to RTI application, the regional office of United India Insurance Company sent me a list of advocates, empaneled in the panel of advocates, in which my name is not included. Since I had not been empaneled in the panel of advocates, it became clear that Mr. Aditya Saurabh is the legal law officer, and MOA comes with the manager and issued a fake fabricated manufactured appointment letter. And Lordship will see, this was lodged on 17/12/25, and his empanelment was in 2024. And he doesn't mention when this so-called indirect bribe was asked from him. What can be indirect bribe, madam?
He has received his appointment on 18/4/2024.
Yes. And the resource code was generated in 2025. There was some delay because of some technical issues. Since you go for the head office. That cannot be a crime. And Lordship will seize the tenor of his RTI application. Just because cases could not be, and he doesn't have any right to claim cases, my lord. Para 50, serial number 15 of the appointment letter clearly says that this empanelment doesn't mean that he will have to be engaged in given cases, my lord. It's a matter of right. Para page 33. Please also note the mere empanelment of panel does not create any right for allotment, and the same should be done on rotation and requirement basis. So there is some delay, my lord. That also that's why I have annexed, my lord, for July 2025. These are there, they after all will allot cases on the basis of empaneled advocates. How can they allot cases to a fake advocate or fakely empaneled advocate? In fact, during the police called them twice. They went there, they could not. They made a statement, the IO was not present. They didn't give a statement also once, And Lordship, we see the sections that have been imposed. Extortion, my lord.
What is this case?
Yes.
Advocates looking for.
Extortion, cheating, all these sections have been brought in, my lord.
This is a unique kind of case where an advocate files FIR against the client, asking him to engage him as his lawyer. Mr. Counsel for the petitioner, additional PP. This is an application under so and so. On the result of the FIR of the case, it appears that the informant, who is an advocate by profession, had sought empanelment with LIC.
No, United India.
United India
Company.
Insurance Company, and had submitted application in this regard. And subsequently, he was issued an appointment letter, but due to delay in generation of the advocate code, the petitioner, comma, being under the apprehension that the appointment letter issued to him was fake, comma, has lodged the instant FIR. Full stop. In the said affair, he has also alleged that some sort of indirect bribe was sought by the petitioners for his impanelment. The appointment order issued to the informant has been annexed to the instant application as annexure
8, page 32.
and it is submitted that the same is a genuine one and there is no question of the petitioners were officials of the company issuing any fake appointment letter. Subsequently, the advocate code was also issued.
Yes, madam. Page 34, madam.
Page
34, annexure 9.
as can be seen from annexure 9. Full stop. There, I find no reason to doubt the genuineness of the documents. Referred to herein above. And it appears that the petitioner, that the informant, under a false impression, lodged the instant FIR, having revert to the above, inclined to dispose of the instant application with a direction that the petition of their arrest shall be released on bail of ₹1,000 with a surety of like amount to the satisfaction of the arrest. Further provided that the shall cooperate with the investigation as in point called for by the IO. Petition stands disposed of.
Privileged.
May I please your lordship? My lord, this is my lord pre-arrest bail application, my lord. This matter, my lord, is out of the same, my lord, affair of item number 3, my lord. So, my lord, this is my lord, AV, my lord, and my humble prayer, my lord, at this stage, my lord, interim protection may be given, my lord, and case diary of both the cases may be called for, my lord, along with medical report.
You've forgotten what is 3.
My lord, what we have been, my lord, our whole, my lord, relatives have been incorporated in the affair, my lord. There, we have also lost affair, my lord. Our affair is page 36 and there, my lord, affair page 13, my lord.
What order was passed in 3?
CD was called for, my lord. So in this case, my lord, I pray for, my lord, interim because, my lord, property dispute, my lord. So, my lord, we have.
This is the which side?
My lord, item 33, my lord.
Item 3, all right.
Yes,
What about this item?
This item, my lord, we pray for interim protection, my lord, because this is a civil dispute, my lord. We have to produce our land document before the IO. That is why, my lord, some interim protection may be given, my lord. We will cooperate, my lord. That's all purpose there.
When we have called?
24 to 25.
Then
My lord, because, my lord, this is
four-
civil dispute, my lord, because
5 days left. Don't argue unnecessarily.
my lord, documents relating to
Yes.
land, my lord, have to be produced.
Along with PA number, my lord, 1646/2026.
CD of both the cases, my lord, kindly, my lord.
Yes, both cases.
Bless, my lord.
Both cases you call? Both cases.
16.
May I please your lordship, my lord?
And in this case, in a contractual obligation, my lord, an FIR has been sought to invoke the criminal lever, my lord.
Page?
Yes, my lord. Page 14 is the FIR, my lord. And the relevant portion starts from page 18, my lord. I was working under one firm, my lord. Naam ki hai sir, wo under-
Buildwell Solutions.
Billwell Solution, my lord. I was working as a employee, my lord, and there, my lord, he is also apprehending arrest, has sought anticipatory bail, my lord. He was granted the privilege of anticipatory bail. I have written there. And one person who was also named in the FIR, my lord, he has also been granted the privilege of PS bail, which has been confirmed. Biswajit. I'm a name accused, so his 4% has been named as an accused, my lord. Hey, Robert, okay. Billwell Solution, Rajendra Prasad Agarwal. I'm accused number 3. Nilkit More. Biswajit Datta was also granted bail, my lord. Rajendra Prasad is on interim bail. I have annexed the order, my lord. It was a contract. The 20% of the material was already placed there to work the start the work. But suddenly, my lord, there was price escalation, so there was a dispute, my lord. I have stated in the paras, my lord, inside that para corner.
Page number 6.
Page 6, my lord. And the FIR was lodged after more than 1 month and 7 days of the alleged happening, my lord. The civil nature dispute has been tried to be converted into criminal nature. And your lordship, in a coordinate bench matter, my lord. Dispute was will be on. Fix as well.
Yes, where is the order?
My lord, at page 29, annexure 4, my lord. I'll go and give my side of the story to the IO, my lord. Because 7 years is the maximum punishment out here, my lord. The rest is all for 5 years, my lord. 2 years. It starts at page 30, my lord. Because the farm belongs to somebody else, my lord. One RK Agarwal, my lord. I was an employee under him, my lord. I was to execute the work.
What is your designation?
I was just an employee of Agarwal concern, my lord. RK Agarwal Billwell. Billwell Solution is situated Lokra, my lord. Rajendra Prasad Agarwal is the proprietor, my lord, and it's a proprietorship concern. The other employee has already been granted bail, my lord, Biswajit, my lord.
Allegation against him is page 21, Lordship, third para. It is also pertinent to mention that during the course of these dealings, one of the accused person, namely Niket Murray, even once instructed us to transfer the amount to his personal bank account, which we outrightly refused to do.
Because that's what, my lord, to buy the materials on cash. That is why there was some delay, my lord.
But Mr. Counsel. PP. This is an application under students. On perusal of the FIR, it appears that the present petitioner is the employee of a firm, namely Billwell
Not Billwell Solution, India.
Solutions, which had entered into an agreement with the informant
Jalan
company,
Golagati
company to set up a solar plant.
Yes,
To set up a solar plant. And pursuant thereto some payment was also made to the executing firm. But
My lord,
due
we
to-
just placed 20% of the material on the site, my lord. It is also in the FIR, my lord.
but due to lack of sufficient progress in execution of the work, the petitioner, the informant, has lodged the instant FIR alleging cheating, forgery, and criminal breach of trust. It is submitted that pursuant to the agreement, some material have already been
20% of the material. my lord.
20% of the material has already
Delivered
been
at the factory
delivered
site.
at the factory site. And it is only because of,
In the meantime, there was.
for
price-
what is the delay, reason for the delay?
But the market price got fluctuated, we have
Because of
stated, my lord.
fluctuation in market price, there has been some delay in
And
execution.
shortage of raw material, my lord.
And shortage of fluctuation in market price and shortage of raw material, there has been delay in execution of the project. As far as the present petitioner is concerned, he is only an employee of the company. Who's the order?
He is also granted pre-years, interim pre-years protection, my lord, Mr. Agarwal, my lord, Rajendra Prasad Agarwal, along with the other man, Biswajit, that I have annexed it, my lord. Page 27, it starts.
Submitted that the proprietor of the company.
Yes,
Of the
property
firm,
of the company has been granted pre-years bail
one
on
Mr.
8/6,
One Mr.
Rajendra Prasad Agarwal.
Rajendra Prasad Agarwal has been granted interim.
Interim, my lord,
Interim.
8/6/26 in AB 1167 by other.
Right that in
Discretion.
interim protection. B. The number.
And Biswajit was
Repeat the number once again. Maybe.
AB 1167 of 26.
By order dated. Order dated.
Order dated 8/6/26.
Similarly, another co-accused.
Biswajit Datta, the representative of Tata Power Solar, he was granted interim bail on 19/5/26 in AB
also been
102.
granted interim bail on 19/5/2026 in order dated
1024.
AB 1024 of 2020.
Which is marked as Annexa 4, my lord.
Para hence call for the CD. The interim, it is provided that in the event of his arrest, the bail of
And the same condition will be good enough because I will go and appear before the
30,000.
IO and give my statement within 7 days, my lord.
one security of like amount to the satisfaction subject to the following conditions, page 31. Okay. Please take again on.
But 10 days I will appear, my lord.
Yes. We have given the same conditions.
My lord.
Same conditions as page
Yes, my lord.
31.
Only 7 days was there. I'm praying for 10 days only, my lord, because
Instead of 7, give 10.
instead of 7, can you make it 10 days, my lord? Much okay.
Second.
Sure, fine. Sure.
Is it a report was called for? We have received a report that no cases, no any case registered against the petition.
Lordship, on 4 occasions, Lordship.
Why did you come?
Raid was conducted in the house of the petitioner's Lordship, Azara police station. But no case was registered in the Azara police station, but person to the which case they have conducted raid, Lordship.
That learned counsel for the petitioner, learned additional PP. The instant arrears bail application was filed as the police from Ajara police station had allegedly raided the premises of the petitioner on 4 occasions.
Yes, sir.
Full stop. Instruction was sought for as to whether any case has been registered against the present petitioner. A report dated 17/6/2026 has been furnished by one SI Porikit. Is all or what? Of Azara police station, PAW, I think. Paul, I think this will be PAUL. Yes, a police station stating that no criminal case has been registered against the present petitioners. Full stop. The present petition hence disposed of with the
Lordship, another prayer, Lordship.
direction that
The instruction is, so far my Lordship, instruction is not completed. Since Lordship, they have conducted raid in my house, Lordship. Pursuant to the which case they had conducted raid, that may be clarified, Lordship. We know, Lordship, no case is registered in the Andhra police
this
station.
is a bail application. Will not keep it a continuous supervisory jurisdiction over the police station now. Disposed of with the direction that no coercive action will be taken against the petitioner without following the due process of law, or in the absence of any case having been registered against the petitioner.
Obliged.
হ্যাঁ প্লিজ লর্ডশিপ আচ্ছা কাইন্ডলি একজন ফর দিস ডে একজন ফর দিস ডে
John,
ইয়েস ম্যাম
parties are all
Represented.
represented. Can copy is received?
Received.
Then you can fix it for hearing. Learned counsel for and learned counsel for.
I am for respondent number 2.
Then number 2. As well as learned additional PP for the state respondent. TCRS call for scan copy of TCRS call for has been received. This is a criminal petition. Okay.
Criminal petition.
Criminal petition is admitted for hearing, list for hearing on of hearing.
Sometimes in the, your lordship, no? Sometimes in the month of August.
Wait, please, your lordship.
Yes.
My lord, here we have assailed the FIR of a particular police station case. Thereafter, my lord, it has come to our knowledge from the affidavit of my learned friend on the other side. My lord, charge sheet has been submitted. So, my lord, that has to be also assailed. For that, my lord, I pray before your lordship to allow me, some time so that we can take out the certified copy and assail the sale by appropriate application.
Mr.
is there, my lord. It may-
Hazarika Learned Counsel for the petitioner submits that during pendency of the instant petition, the charge sheet has been submitted.
The certificate of such, my lord.
Yes.
In
My lord, not during the pendency.
Scan copy has
Before.
been received, all for it is received, my
At
lord.
the time of filing, we didn't have. At the time of filing, my lord, we didn't have that knowledge.
And in my
Charge sheet has been
objection, I have
submitted.
filed a certified copy of the order, my lord.
From their affidavit
Charge
only
sheet,
we
my
come
lord.
to know, my lord.
Here, my lord, matter is urgent, my lord, after taking money from my client, that's one number two, for the inner decorator, he has filed a case against him in the online Gauhati. From online there, when
My
he
lord.
went to visit the site, the group of people has made attempt to kill him and demanded rupees 30 lakh.
My lord,
my
on
lord.
maritime not
But
submitting right.
that
my lord.
was that he stated to have.
Our
taken
FIR was
the
in
location
fasting
down.
time.
But instead of doing it, he came to Gauhati and file an FIR online. And thereafter, when my client has found that after taking the money, he did not continue the work, he has filed this FIR, on the basis of which police, after making investigation, has submitted charge sheet under section 418, my lord. Now the moot point, my lord, when the charge sheet is submitted, whether it is a case, whether your lordship can exercise jurisdiction under section 482 of CRPC, my lord, the causing. That the law is very clear. It is settled by the Supreme Court in the lot of cases, mainly Bhajanlal case, which is the leading case of the Supreme Court, my lord, in causing matter. Causing matter, the guideline has been given where the power can be exercised, my lord. Here the.
My lord, at this stage, my lord, I am just praying, my lord. I have to bring on record the charge sheet.
The criminal
and the proceeding thereof.
when can be caused? High Court in exercising jurisdiction.
No, we are not hearing on
482.
merits now. We are confined to the limited prayer that he wants to put the charge sheet to challenge.
Yes.
That is all.
That much, my lord.
Moreover, stay order is up to today, my lord.
That
If
may be
your
extended.
lordship affects under that, the stay order may can be vacated, my lord. The solicitor case, the court will try whether who is correct or who is incorrect, that will be decided, but not a case of forcing, my lord. Law is very clear. Lot of Supreme Court decisions.
The charge sheet has been filed, and at the status of charge also you can apply for discharge if no case is made out.
My lord, but I am not today. If your lordship wants to go on merit, my lord, I can do that. Our FIR was fasting time, my lord. I am a fashion this interior decorator, my lord. For some reason, the work could not be done, and I have cited the reason at proper time. And thereafter, my lord, while I was in their place at Lakhimpur,
certain criminal activities, my lord, has happened. So therefore, I have filed an FIR on 9th. And this particular FIR was filed on the 12th, after 3 days. After knowing that, we have filed an FIR. And matter relates to, my lord, purely of civil in nature. Contractual matter, my lord. Purely civil. Maximum, my lord.
But for sitting criminal offences, dear my lord. Yes, seated, my client.
Not at all, my lord. There's a breach, at maximum, there may be a breach of contract, my lord.
But I have filed a certified copy of the charge sheet in my objection petition, my lord. Filed on 9/2026.
We can file an application for challenging the
Yes, my lord.
charge sheet.
Yes.
That we cannot stop him.
Yes, my lord.
Mr. So-and-so learned for the petitioner submits that at the earlier one, okay? At the time of filing of the present application, it was not known to the petitioner that the charge sheet has been submitted. Which fact came to his knowledge upon the affidavit being filed by the respondent. So accordingly, counsel for the petitioner submits, he may be permitted some time to put to challenge the charge sheet as well. But Mr. Sen, counsel for the respondent number 2.
Yes, respondent number 2, my lord.
2, my lord, respondent 2.
Presses on the urgency of the matter. Full stop. In regard to the above. The petitioner is allowed to submit appropriate application as prayed for within a period of 2 weeks.
And vacation will be there, my lord. Let it be immediately after vacation, my lord.
Is the matter immediately after vacation?
Yes.
You can file it 1 whole week is there.
Yes, my lord. In the meantime, we'll file it before the date, my lord.
The matter on reopening of Pishote did.
Till then, my interim may continue.
Till the next date of listing.
My lord, interim period, my lord, may continue.
Yes.
Yes. Deeply obliged, my lord.
Number 20.
May I please your lordship? Lordship, I am for the petitioner. The petitioner is serving the sentence in district jail since 30/4/2020. We have served the copies, lordship. And LCR is not yet received.
It's here not received.
Yes, lordship.
LCR
Delay has been duly condoned.
PCR has not yet been received. Issue reminder list again on. So same order in both IAN.
Pardon? Obliged, lordship.
21.
So we are challenging the, my lord, order taking cognizance, my lord.
And my lord, your lordship was to consider today for stay of the cognizance order. Now we have taken ground that, my lord, that there was no written.
Who are you?
Appearing on behalf of respondent number, I filed Vagalatnama last week, Lordship. 2 weeks time may be granted to file affidavit.
Our, my lord, that cognizance order 61 page. That may be state, your lordship. Then apparently there was some delay, my lord, in their filing, and there was no written agreement, my lord, no contract. I have lost complaint to the bank regarding my checks were misused, lost. There is nothing to show that I have any legally enforceable document.
Today is only fixed for service.
It has come for admission, my lord, your lordship. And
As per last order, it was registry is directed to place postal track record.
since they have appeared, my lord,
They have appeared, they will file objection, definitely.
only thing, my lord, that next date is on 7th of July. Your lordship will record my submission on.
For what?
Regarding the order of cognizance, page 61, my lord.
Now it is fixed for what now?
Now for appearance, my lord. The lady, my lord, she has not any enforceable debt, nor any written agreement. Your lordship will see entire complaint petition is, nothing has been annexed. And order of cognizance has been taken, my lord, very mechanically, my lord. When we are ascertaining the, my lord, delivery of notice or not. Lordship allow, then I can argue also. Only till next day, your lordship, then since they are appearing, my lord, that will be kept suspended till the next day only, my lord. Your lordship may fix it on opening day, my lord.
I'd heard Mr. Learned from the petitioner and so enters appearance for the sole respondent. And 2 weeks time to file objection. Prayer is allowed. It on behalf of the petitioner. Pursuant to cognizance taken on 19/1/2026, the matter is now quick. When?
7th July, my lord.
7th of July.
For appearance.
For appearance. It is provided that the petitioner accused is exempted from appearance on the said date. And learned court may fix another date for appearance. The matter. Reopening.
Can it be on, my lord? 15, my lord. 15, sir. Since lordship has. August.
22. May I please, Lordship? Lordship, and this is an application under 528 and 482, Lordship, and it's a proximate, Lordship. In this case, Lordship, charge was filed on 31st of May 2025. Annexer B, I have annexed, Lordship, page number 14. Here, Lordship, I have been declared as a proclaimed offender, Lordship. However, in this case, Lordship, I didn't have any knowledge that a case has been registered against me, Lordship. And also order dated 24/9/2025. That also I have annexed in Annexer C, page number 23, Lordship. So in this regard, Lordship, the case is for appearance, Lordship. Protection is given to me. I will face the trial, Lordship.
What do you were not aware?
Yes, Lordship.
The case.
Yes, Lordship.
You did not receive notice.
No, Lordship.
Were you Zainuddin?
Yes, Lordship.
You're absconding during investigation.
Lordship, I didn't receive any notice, neither the police came in search
Police
of.
visited your house 3 times according to the case diary. House search memo is also there, signed by witnesses. Allegation is also serious.
I will
Section
face
4
the trial.
POCSO. You cannot avoid jail by simply hiding yourself. And then when the charge sheet is filed, appear there.
There, my lord, in the search sheet, it is stated as my lord proclaim offender, my lord.
Yes.
The main accused, my lord, and a girl is 11 years old, my lord. That, my lord, regarding that part, this is not come to the notice during the period of investigation, my lord. They come to know.
Chief, I'm ready to appear, but some protection is given.
Till you appear, we can grant. Till the date of your appearance.
Okay. Dream may be given.
Counsel for the petitioner and heard you are for amicus.
Amicus, yes.
You have to the informant. It is submitted that the charge sheet the case has been submitted pursuant to which special POCSO case number 75 of 25 has been registered and on the prayer of the IO. WA as well as PNA were issued against the petitioner and subsequently he was declared as a proclaimed offender. The limited prayer made in the instant petition is that the petitioner may be granted some protection till his appearance before the learned trial court. Heard the learned counsel for the petitioner and learned additional. This petition is disposed of with the direction that the petitioner shall appear before the learned trial court within a period of. The date has been fixed in a period of 10 days from today. During this period, the petitioner shall not be arrested. Made clear that this limited order of protection shall extend only up to 10 days from the date of this order or earlier, or till the petitioner appears before the learned trial court, whichever is earlier. Further provided that on appearance in the event of any application filed by the petitioner, the same shall be considered as per law. Petition stands disposed of accordingly.
Supplementary 57.
Please, Your Lordship, Lordship, matter may be taken after some time. My Lord, arguing counsel B. Brogma is on leg, my Lord. In another.
Finding item 6.
Please, Your Lordship. This is a regular bail application behind the bar since 1/6/2026. It's Jalukbari PS case. Only limited prayer is the CD may be called for. Let the matter be fixed at the earliest. 26th is possible. 26/6. My pleasure, Lordship. This matter was amicably settled at police station. There is a report probably. In this case, Lordship, although FIR was not registered, apprehension was there initially. So petitioner approached this honorable court and order was passed. So there is a report probably in this case from the police station.
The matter is settled, you simply withdraw. What is there? It is submitted by learned counsel for the petitioner that the matter has already been settled between the parties and at present there is no apprehension of arrest. Accordingly, the petition stands dismissed on withdrawal.
Deeply obliged.
Report may be, my Lord, taken as a part of the record.
Report submitted by whom?
FIR were actually not registered at that time.
Inquiry officer kept on the record.
Obliged.
Not date to side over. Dated so submit.
Hearing BA 23.
Your Lordship. It's a regular bail application. The petitioners have already been released on interim bail, my Lord, by order dated
2023 to 2026, primarily on two grounds, my lord. The case otherwise registered under section 103 of the BNS. Another FIR preceding this FIR had already been lodged. And in that case, the main accused had been arrested. Subsequently, the second FIR lodged, which otherwise does not disclose any allegation of murder. And second aspect was, my lord, non-compliance of 47 and 48. Your lordship will kindly see first the first FIR, my lord, which your lordship will find at page 13, my lord. This FIR was lodged by, my lord, the nephew of the deceased, my lord. Your lordship will kindly see. It is respectfully stated herein that the accused number one, this one, Junaid Ahmed, had been bothering my sister Semim Akhtar with his proposal for love for some time. She is now married to someone else. In spite of that, yesterday on 10/1/2026, at around 10:30 p.m., the accused number one, along with two unknown persons, came to the front of Semim Akhtar's house. When my uncle Ziabur Rahman came to know of it, he tried to apprehend the accused persons. However, the accused persons pulled him inside a three-wheeler vehicle in which they had come and dragged him towards Doghouse. The accused persons attacked him on his head inside the vehicle and caused him grievous injuries. They pushed him out in front of A. Malek's house. We immediately took him to Doghouse Hospital. But seeing his condition, the doctors referred him. Currently, he is in the ICU of Aditya Hospital in a critical condition. This was initially registered under 109, my lord. Subsequently, the victim died. And at page, my lord, 19, 103 was added to the case, my lord. And one Ali Muddin, my lord, one Ali Muddin was arrested for this accusation. Now, this FIR was lodged immediately after the incident. Around 9 days thereafter, my lord, the second FIR came to be lodged, which your lordship will find at page 21, my lord. Sorry, my lord, 28, my lord. So, well, 28 is the forwarding, 21 is the FIR, my lord, second FIR. 9 days after this, now the deceased person's wife lodges this FIR. The informant respectfully states that on 10/1/2026.
Original was lodged by one
nephew.
Mizazur Rahman,
Mizanu is the nephew of the deceased, my lord.
nephew of deceased. Then
Because-
this affair by Parvina Sultana.
She's the wife.
Wife.
After 9 days, my lord.
Same incident.
Same incident. The informant respectfully states that on 10/1/2026 at around 9:30 p.m., accused number one called my husband Ziabur Rahman over the phone and asked him to come to his house. After some time, upon hearing people shouting and a commotion, I could not find my husband nearby. I tried calling him, but I did not get any response. During the second call, I could not hear my husband's voice. Instead, I heard chaotic noises on the phone and proceeded to find him lying unconscious near the house of Abdul Malik. The aforementioned accused persons were surrounding Ziabur Rahman, holding lathis, rods, and other weapons in their hands. When I reached there, accused number two deleted the data stored in my husband's phone and handed it over to me. I immediately took him to Doghouse Health Center, but he was referred to Nagaon for better treatment. So and so, so and so. Subsequently, he died. What happened was this Junaid Ahmed had been bothering the niece. He came to take her away. Ziabur Rahman tried to apprehend Junaid Ahmed and the other two persons. He was attacked by Junaid Ahmed and his accomplices, sustained injuries, and he died. This FIR says that we were also present around the locality where this body was found and we had weapons. So this part we have also explained and we have not denied our presence there because this had happened after Junaid Ahmed had attacked the deceased, my lord, and the people had already gathered there and commotion had happened. So these persons were there. Now already an FIR was registered. This was being investigated. 103 was there. So this pertaining to the same incident becomes a second FIR. Now the other issue, my lord, will find from page 32, my lord. The notices under 47, 48 and the arrest memo.
Otherwise, is there any material against them?
When he was, as per the this is concerned, Lordship, the reason is that they have pulled him to the rickshaw and they assaulted them and thrown up from the rickshaw, auto rickshaw.
As against those people?
Yes, those people.
Present petitioner?
Present
petitioner is
present petitioners. They were in the auto rickshaw, as per the witnesses concerned, Lordship. When he sustained injury, after he was taken to hospital.
no in the FIR. Who was named in the first FIR?
First FIR,
Mizan.
Junaid Ahmed and two unknown persons. Here, my lord, 6 persons who are otherwise from that vicinity.
So they are here there are 4 petitioners.
Yeah, Lordship.
So there were 3 persons in the auto rickshaw.
Three persons in that also.
So these
That
are,
person's name was there here also, but as per the witness, three persons are there. One is Fakhruddin, his name is Bablu is there. But
one is Junaid Ahmed.
yes, Junaid Ahmed is responding. He is not arrested yet.
In the auto rickshaw,
Yes.
there is one Junaid Ahmed.
Junaid Ahmed.
Who are the other two?
Other two, one is as per the statement Alimuddin and
Alimuddin or
Yes.
Alaluddin?
Alaluddin,
Alaluddin.
and Fakhruddin.
Fakhruddin.
There was one Alimuddin who was already arrested in the first case.
Alaluddin and Fakhruddin.
The material is there.
Yes, Dr. And after that, final opinion of the date was due to hypertrophic cardiomyopathy, injuries described in the PM report were antemortem and caused by blunt force impact.
Madam,
Now what is, how about? Yes,
the arrest memos in the notices, my lord, page 32, my lord. 32 onwards, my lord. Jomiruddin, this is for Jomiruddin, my lord. He is the petitioner number 4. No accusation of the offences. Only thing, আটকাধীন অভিযুক্ত ব্যক্তি সকলক FIR named অভিযুক্ত গ্রেপ্তার করা অভিযুক্ত ব্যক্তির বিরুদ্ধে গোচর হতে জড়িত থাকার পর্যাপ্ত নির্ণায়ক প্রমাণ পোৱা গ'ল। যদি অভিযুক্তক গ্রেপ্তার কৰা নগ'ল, তেওঁলোক পলায়ন বা আইনৰ প্ৰক্ৰিয়া এৰাই চলাৰ সম্ভাৱনা আছে। The substance of the accusation, what is the accusation? That is not there. This is the 47 notice. Page 35 is the 48 notice. Same, my lord, for all the accused persons. The substance of the accusation missing. Arrest memo also same, my lord, that I have also annexed.
page.
Arrest memo for Jomiruddin, your lordship will find at page 36.
So nowhere.
Yes. Already sufficient conclusive evidence have been found against the arrested person having involvement in this case. In the Assamese portion, in the 47 notice, that part of what গ্রেপ্তার কৰা অভিযুক্ত ব্যক্তিসকলৰ বিৰুদ্ধে গোচৰৰ সৈতে জড়িত থকা পৰ্যাপ্ত নিৰ্ণয় প্ৰমাণ পোৱা গৈছে।
Where is the order? Which date order of
Interim, my lord, page, order dated 23/2/2026.
Right, heard Mr. Counsel for the petitioner and then additional EP. An application under so and so. Paragraph 3 of order dated 23/2/26. CD as called for has been received. Perusal of the said CD. It is submitted by learned PP that there is real to show that the petitioners number 1 and 3.
Yes.
1 and 2.
Fakhruddin.
Fakhruddin and Alamuddin.
1 and 2.
1 and
1 and 2. Material against the petitioners number 1 and 2. Nawaz Learned Counsel has taken the court through the arrest memos and notices under section 47/48 BNSS furnished to the petitioners. The perusal of the said notices would show that in none of the said notices or arrest memos were the grounds of arrest mentioned. Full stop. The above being in clear violation of the statutory mandate as well as the directions of the Honorable Apex Court in Vihan Kumar versus State of Haryana. Petition. The petitioners are entitled to bail. And accordingly, the order of interim bail dated 23/2/26 is hereby made absolute upon the same conditions. Stanza law.
I'm deeply obliged, madam.
Before 20 probably we have received the case diary, but PM report is not available here. It is registered under section 103. Yes, sir. Yet na hono ite. Yet.
What is the name of the main accused?
From Mohan Rajbangshi. It could be in the city now, city nine.
So suicide or 103, for that we need the postmortem report.
Yes.
Lordship, I have inquired yesterday in the office of the PP's Lordship. PM report was available on that day, Lordship. Kindly matter may be taken up at 2, Lordship. Then.
I'll let you check up.
Two dot. Is available then.
25.
Please, your lordship, regular bill lordship, 36 days behind the but allegation regarding that the informant has paid the money to the accused person for providing job lordship, and later on it was found that certificates were fake and it was not genuine lordship. But whereas in the FIR itself mentioned that the money 2 times has been paid by the informant, but not to the directly to the accused person in some other person account number lordship. This is the case, and he was arrested on basis of this allegation, and for last 36 days he is behind the bar. Other custodial detention. The FIR lordship clearly says an account number and along with the person whose account is this lordship has been mentioned in the FIR, but both the account number and belongs to other person lordship, not to me.
The accused lordship made the complaint to Facebook lordship, and he falsely identified himself as an employee of the Assam Secretary Health Department. When the complainant attended an interview for a PGD teacher position, the accused made her promise to secure a job exchange of 6.5 lakhs. He subsequently convinced her to transfer 4 lakhs to various UPI IDs and bank accounts after presenting a forced selection list. And lordship is a habitual offender. 22 criminal cases are registered against in various different PS lordship all over Assam.
He has been paid online.
Lordship.
Not to him, Lordship, that it is specifically mentioned in the FI to different person, Lordship. That first one is one Sanidul Islam, the account number and everything has been given. Page 12, Lordship will kindly say of the FI, Lordship. Page 12. That the mid part, Lordship, I have paid through phone pay in several installment in the number so and so, is account number so and so.
Even if it is paid to someone else, it is
Lordship,
paid
and the
on
second
NPS.
one, Lordship will kindly see that down below, Lordship,
Yes.
down below on the same page, Lordship. That given the Sunrama Hotel through online UPI, Mrs. Barsa Burman, so and so number, and thereafter Rajesh Das, an amount of rupees 1 lakh. Not to this person directly.
Yes, that much alertness even we have.
Even
To take it in our own name.
36 days, Lordship, and PPS submitted previous case also there, Lordship. There-
36
no
days
chance
and
of-
how many lakhs?
No chance of absconding.
How
Lordship.
many lakhs?
Witnesses examined, several victims also examined. So he has treated many persons, Lordship.
Considering the Lordship.
Counsel for the petitioner and additional PP. This is an application under the allegation against the petitioner is that by posing himself as an employee of Assam Secretariat, he represented to the informant victim that he could obtain employment for her in a government job. Accordingly, the informant paid large sums of money. The said purpose into the accounts of different persons. Also showed her fake selection lists. The did not get any job, and the informant did not get any job, and the petitioner swindled the informant out of a total amount of rupees 12,50,000. So the petitioner submits that having regard to the period of detention of 35 days, custody may not be required. On the other hand, learned additional PP reference to the CD submits that there is sufficient incriminating material against the petitioner involved in cases of several other cases of similar involving duping of job seeking candidates to the of the allegations and the gravity of the offense. The prayer for bail stands rejected at this stage.
Much obliged, Your Lordship. Much obliged, Lordship.
And then the second. Yes.
Your Lordship, may I please, Your Lordship, their petitioner is behind the bar from 46 days, Lordship. What happened, Lordship? One of the accused person used my center account number to receive cheated money, Lordship. I am just a merchant, Lordship. I am the owner of the CSC center, Lordship. Lordship, FIR is page number 11, Lordship. May I read, Lordship?
Yes.
I respectfully submit that since 2006, I have been associated with a person named Jivan Tanti. Lordship, typical mistake, it's a depend Tanti. On 1st September, Dipentanti informed me over phone that he had obtained the post of the executive member in Oil India Limited and that Dr. Rajiv Kumar Mohato had become executive chairman. He stated that Oil India Limited currently requires 15 Scorpio vehicle and that each vehicle would earn around 1,30,000 per month. He further said that Oil India Limited had issued a tender and that work orders would be given after depositing the tender payment through online transfer. Believing his statement, I agreed to provide 10 Scorpio vehicle. Later, he informed me that the monthly amount for each Scorpio vehicle had been increased. Following communication through WhatsApp, he instructed me to transfer money online. Lordship, this is my center's account, Lordship. And Lordship, Rajiv Kumar Mohato used my center's account to receive cheated money. I am just a merchant, Lordship. And after arrest, Lordship, Rajiv Kumar Mohato was expired, Lordship. This is the certified copy of the Chief. Another accused Dipentanti, Lordship. He is on interim, Lordship. Lordship, I am just a merchant, Lordship. I am the owner of this.
Who is on interim?
I don't have personal contact.
What is your name?
Lordship. Asfakul Sharma, Lordship.
Asfakul Sheikh.
Sheikh, Lordship.
Asfakul Sheikh.
I don't have personal contact with the Rajiv Kumar Mahato. He is just my customer, Lordship.
So here, Lordship, main allegation against going to FIR and Roto case there against Rajiv Kumar Mahato and Dipen Tati, who introduced themselves the officials and associates of All India Limited, and they have common intention to deliberately misrepresent facts and created false confidence and obtaining huge amounts of money from the various persons, Lordship. With providing some, Lordship, fake tenders, providing some cars, Lordship, in the All India Limited, Lordship. But some amounts were transacted to the account of the petitioner, Lordship. It's an Assam
Must have
online
got a
account of the
commission there.
petitioner, Lordship.
How was his account used? Money was deposited in his account.
Yes. Money was deposited in his account and sometime he transferred also to other accounts also. That
Just customer, Lordship. I took nominal charge, Lordship. I have a license, Lordship, that has been annexed, Lordship.
You have a customer service center.
Yes, Lordship. I have license,
We
Lordship.
have seen in many earlier cases also these accounts of these people of customer service centers are used. Even in fake ATMs and all those many cases. Why particularly these people, I don't know. Customer service center people, they are being used for some reason.
yes, maximum part they have their accounts are used, Lordship. Transferring the amount, Lordship.
I am falsely
Maybe they are more accessible.
implicated.
Yes. In his statement, Lordship, he has stated that his petitioner, Adip Kumar Mahato instructed him to collect the money. That's why he collected it.
How many days?
46 days, Lordship.
6 days. Heard learned counsel for the petitioner. An application under so and so. The summary of the prosecution case is that the informant had a good relationship with one Dipen Tati, who informed him that he has been selected to a high office in Oil India Limited along with his friend Rajiv Kumar Mahato, and they were in a position to award contracts for hiring of vehicles. And acting on the said representation, petitioner paid an amount of 4 lakh and thereafter another amount of rupees 2,70,000. The account of one Assam Online. Subsequently, also, the purpose of getting the contract paid rupees 3,90,700 Rajiv Kumar Mahato. This manner, large amount of money was extracted from the informant. By the above named persons, but the petitioner did not, the informant did not get any benefit therefrom. Page 36, paragraph 4. On perusal of the case diary, the learned edition submits that the present petitioner allowed the CSC, his CSC account situated at Moran to be used by the accused persons to receive money. And approximately around rupees 1 crore has been deposited in the said CSC account of the present petitioner, which was later on transferred to Rajiv Kumar Mahato, since deceased. Para. Must have been granted police remand earlier.
Yes.
Forwarding it to the-
That I have to disseminate.
forwarding it to the- to the same office, I think.
Having
No
regard to
question.
the fact that the petitioner prima facie did not have any direct role as far as the deception of the informant is concerned and merely allowed his account to be utilized. And also having regard to the fact that the police had sufficient opportunity to interrogate the petitioner, as well as the period of detention of 46 days, 6 days in custody. Therefore, bail is allowed. 1 lakh to sureties.
Highly obliged.
Please, your lordship. Here, your lordship, LCR was called for. So far, LCR not received. He is behind the bar for 50 days, my lord. Offense is, my lord, not for non-appearance in the trial court.
Original offense being
Original offense that he was on bail, my lord. Thereafter, some present, my lord, not present. He went to Kerala, my lord. Simple, he is doing daily labor, my lord. Communication gap was there with his counsel, my lord. Page, page 29 is impugn order, my lord, a reject order by the court below. Page 31, my lord, para 6, that is the, my lord, ground, so where it was rejected. Page 31, para 6.
So what happened on 2/6/26?
Evidence,
for
my lord,
evidence.
it was fixed for evidence, my lord.
Yes, you have no instruction what happened.
That instruction is not with me because the LCR was called for, that is not received, my lord.
You should have had the instruction.
My lord.
Then we'll wait for the LCR. LCR is called for not received. Issue reminder list again on.
Early death? Any early death? Because he is behind the bars. Yes.
You have received the case diary.
Wait, please, your lordship.
I have made a prayer for fixed for another date, lordship.
My lord, today I am behind the bars for, my lord, 66 days, my lord. It's a short affair. Kindly, lordship, have a look at page 9, my lord.
What can we do? It's 103.
103, my lord, my role, my lord, that is there, my lord. Can I place the, my lord, page 19, the forwarding report, my lord, for a once, my lord. Page 19, my lord. My lord, the grounds of arrest, my lord. The accused Jalaluddin is the affair named accused person who is found to be indirectly involved in the commission of the crime in murder of the deceased and causing grievous injury to other injured person. Indirectly, my lord. During investigation, it is revealed that the accused had prior knowledge of the occurrence of this heinous crime and has shared common intention with the main accused person who are now evading after commission of this offense. And on the next page, my lord, arrested accused person assisted to the main accused person before / after the occurrence by facilitating their movements and helping them escape from the place of occurrence, my lord. And number 5, my lord, witness statement and other materials collected during investigation suggest the involvement of the arrested accused person in aiding the commission of the offense, my lord. And from the IO, my lord, it is clearly, my lord, I am not directly involved, my lord, indirectly, my lord.
Is direct, indirect.
My lord, like the why?
What is the case?
All right.
I'm for the
20
informal note.
Hmm?
I'm for the informal.
Next because.
25/6. My name may be reflected.
25/6.
Fermented appears
Yes,
for
ma'am.
info.
I'm obliged.
Yes, wrong. Time. 35.
May it please your lordship. This is a case involving road rage, your lordship. The allegation is of attempt to murder and grievous hurt. But what happens, lordship, the petitioner herein is an advocate. Now, while traveling by his bike in the night time, his scooty overtook him from the left side. So he had an altercation with the rider of that scooty, and at the heat of the moment, he slapped him, your lordship. And when that person fell down and he received injuries in his head. So now the police have lodged the FIR at the instance of the mother of the injured person, and I have been lodged under attempt to murder and grievous hurt, your lordship. My humble submission, your lordship, attempt to murder case is not made out. Grievous hurt may be, your lordship. The grievous hurt already I am 20 days, 28 days behind the bar, your lordship. Grievous hurt, otherwise punishment is below 7 years. So I may be given the benefit of the judgment of Satrendra Antil and Arnesh Kumar, you know. This is my humble submission. And the only ground on the basis of which, in my grounds of arrest, your lordship will find the reason why notice was not issued, because I may evade appearance before the court. That's why, my lordship. Is the only ground.
What is the case registered under?
Case registered under 117(2) and 109. 109, your lordship.
If 109 is there, where is 35?
Lordship, 109 in my humble submission, your lordship, it will not come in because intention has to be there. Even in
Those are matters of trial.
trial, your lordship. But at this stage,
As per the injury report, injury is grievous.
injury is grave.
Head, upper tissue, upper lip, lordship.
Huh?
Head and upper tissue, upper lip. It was broken, lordship. And as eyewitnesses there, he's implicated the petitioner. As per the eyewitness, lordship, boys, both of the parties had two-wheeler and they had an argument. After some time, the man with beard had hit one boy with his helmet and the boy fell down. I immediately went to the spot and talked up to the person, and he told me that his name is Harpreet Singh and he was under influence of alcohol. His eyewitness statement, lordship. Injury sustained by the victim is grievous.
The injured person is discharged from the hospital. Lordship, and considering the length of detention, already 28 days is custody, and it was not premeditated, your lordship. At the heat of the moment, it is a case of road rage. There was no criminal intent on the part of the petitioner. Unfortunately, he received serious injury, but
Maybe because you are advocate, you thought you were immune from the law.
no, your lordship. That's not the case, your lordship. That boy is also a law student, and only later on he came to know. There was an altercation because that boy is quite young and he was using very filthy language, your lordship. So he got infuriated. In fact, the petitioner's mother is dead. So some explicit language was used against his mother also. So that's why he did not
intent to hurt him so previously, Your Lordship. Your case of accidental injury, Your Lordship, so there was an alteration. There was no intention to harm him so severely.
What was the instrument used?
Helmet.
Helmet. Is the nature of the head injury?
So the head injury, Lordship. Right frontotemporal contusion with acute SDH. Contusion. And broken teeth, upper 2 incisor. And cut injury, left upper lip.
No internal bleeding, Your Lordship, as averred in the affair. Confusion, already he is discharged also. And as per information received, he is now normal. But
28 days, you say?
28 days, including today.
Forwarding report is 23/5.
23/5 I was forwarded.
Heard learned counsel for the petition and learned additional PP. This is an application under. So the allegation as per the FIR is that on 23/05/26, the petitioner was involved in an altercation with the third person. At Ganeshguri flyover, while they were traveling in their respective vehicles, and course of such altercation, the petitioner struck the injured with his helmet, causing injury to the head and teeth of the victim. Para the learned counsel for the petitioner submits that this is a case of road rage, RAGE. There was no intention on the part of the petitioner cause death of the death of the injured person. And section 109 BNS may not be attracted in the facts of the present case. Further submitted that petitioner has since been the injured person has since been discharged from hospital, and the petitioner has been languishing in jail for the last 28 days. Learned additional PP perusal of the medical report submits that the petitioner suffered contusion on his which part? Right frontal lobe, no?
Upper head. Or right frontal.
Right?
Frontal.
Right front lobe. And also teeth. Two of his teeth
Two of his teeth.
were broken. Perusal of the deal on record, there does not appear to have been any premeditation on the part of the petitioner. The incident occurred on the spur of the moment. To the above, as well as the period of detention of 8 days in custody. Further detention of the petitioner may not be accordingly. It is allowed 50,000 on surety. Section of the Tornado Magistrate. Commission cooperate with the investigation.
Supplementary 58.
Much of.
May I please, your lordship, in this case, your lordship, yesterday, your lordship learned of APP, your lordship sought time to take instruction as to whether 35(3) notice was served on the petitioner before arrest or not, your lordship. And I have shown from the forwarding that no such notice was served, your lordship. The allegations, cases under offenses under which this case is registered, both are, your lordship. Maximum punishment is up to 7 years, your lordship. Going by the dictum of the Honorable Apex Court, your lordship, 35(3) notice is mandatory in nature, your lordship. That has not been followed, your lordship. That is why, your lordship.
No, unless he has reasons to arrest him.
That is your lordship. That is page 21 is the FIR, your lordship.
But checklist is there.
Checklist is there, my lord.
Other than that,
my lord, there is the implication, my lord. That my learned friend complained, my lord, after the trial submission.
no, I think he has completed that day also.
Lordship,
Still.
Checklist is there, my lords.
Only thing we are concerned with is there any justification for his arrest without issuing notice under 35(3)? Has he recorded any reason why his arrest is necessary? That is all we have to see. Tick mark will not do.
Tick mark is not there, my lord. It is, my lord, mentioned as a yes, my lord. Whether the police officer is satisfied that the arrest is necessary, yes, my lord.
Yes is tick mark.
Yes. No, not tick mark, yes.
All right.
Yes. Prevent the person from committing any further offense, yes, my lord. And facts, my the other reason also giving, my lord, why he was arrested, my lord.
And on merit, your lordship, my submission was that, your lordship, that for extortion to be taken place, your lordship, the delivery will have, property will have to be there, your lordship. And the face of the allegation, as well as the grounds of arrest in the arrest memo, no delivery of property has taken. It is alleged that I have demanded rupees 2 lakhs, your lordship. That is the fact, your lordship. Will not come under this, your lordship, 3084 or 3082.
During investigation, he fails to comply with terms of notice. Where is the notice? Can't make any head or tail out of this reason. During investigation, the person fails to comply with the terms of the notice or is unwilling to identify himself, comma, he may subject to such orders as may have been passed by a competent court in his behalf, comma, arrest him for the offense mentioned in this notice. I don't know if you can make out any meaning from this.
My lord, he can't. My lord, he was, my lord, asked to come, my lord. Probably he has not cooperated, my lord.
Where is that asking? Merely saying that I telephoned him or something. That is not, that is the very reason why these provisions are there for written notices. Otherwise, anybody can say, I called him up, he did not come. What was the allegation about?
Allegation, your lordship, of demanding money and claiming to be close to political leaders, including Honorable Chief Minister and others, your lordship. That is his case. But my case is that, your lordship, what has happened on that day, your lordship, I went to one Majida Begum, your lordship, who claimed that after depositing an 11,000 rupees, 11,000 to the school authorities, they have not given them the uniform, school book, textbooks, etc. That is why I went there, your lordship. That is what and I have submitted a complaint to the police also, informing that this has happened. And police also went with me, one of the police officer, your lordship, on that day. But still thereafter, your lordship, he himself returned 11,000 to this lady, your lordship. Then he lost this affair, your lordship, claiming that I have demanded rupees 2 lakhs. And it is not his case that he has paid me that rupees 2 lakh, your lordship.
My lord, he is no way connected to the school, my lord. Only on the behest of one, my lord, lady, my lord, whose son is, my lord, in the school, my lord, in the preschool, my lord.
But that be, you cannot overcome this like, you know.
My lord, on 48 notice, my lord, sorry, 36, that is not clear, my lord.
Yes, no pass orders.
At 11,000, it was returned, my lord, I think.
Lordship.
Pass order.
Lordship. Deeply obliged.
This is included there, but in
30
Received.
case that is not received, my lord.
They did not received interim pastor.
got bail in interim bail in February, in December 2025, Lordship. Till that we are waiting
Don't
for
have time
CD.
for all this now. Yes. Next.
32
May it please your lordship, CD is not available in this matter. And I'm entering since.
My lord, in this case, search is submitted, my lord.
Sheet submitted.
My lord.
What is the section
Section, my lord.
presently?
Yes, my lord, present section, my lord, as per the FIR, my lord. It's 3162, 3184, 338, and 35, my lord.
You see, we'll appear before the trial court.
Master Tribal. Heard learned counsel for the petitioner. Learned additional PP submits that CS has already been submitted by CS number.
CS number 85/2026, dated 25/4/2026.
For the petitioner submits that the petitioner shall appear before the learned trial court and apply for regular bail. Accordingly, the petition is disposed of with the direction that the petitioner shall appear before the learned trial court within a period of 10 days.
10 days, Doctor.
10 days from today. Till then, the order of interim protection shall remain in force. Don't say till then, and the order of interim protection shall remain in force till period of 10 days from or till the appearance of the petitioner before the learned trial court, whichever is earlier. Petition stands.
Deeply obliged, Lordship.
34. 34.
Pass over for the time being.
Let it be in the next week, madam. Huh? Yeah.
All right. Did you receive?
Yes, there is, madam.
36.
36, my lord. 36.
Interim lordship.
36, my lord, we have received the case there, my lord, but the FSL, sorry, my lord, PM report is not received, my lord. It's a case of suicide, my lord.
CD is received, but PM report is
report
not
will be required.
available. List again on so and so interim
After
order
vacation,
passed
madam.
earlier, continue till the next.
24/7.
Obliged. My please, Your Lordship.
30.
30.
Okay. 38, my lord, case, Sakshi submitted, my lord.
Chief, I am in interim.
So what do you want now?
Kindly absolute the interim matter. You.
30 submitted, my lord, that I have observations.
Then we'll have to see the CD. What is that?
Lordship.
CS has been submitted. It's number so and so. Call for
Case
the
number
scan,
68/2026,
scan
dated
copy of the TCR
6/2026.
interim order. Set of list.
Lordship.
Sorry, my lord.
39 adjourned.
My lord, 35, lordship, both of us are here, but somebody mentioned, we are not aware about that.
30?
5, lordship. I am for the
35, somebody said 2 o'clock, I think. Which
Maybe-
one was fixed at 2?
I am for the petitioner and he is
35, my lord, already Sakshi submitted, my lord.
Oh.
35. Dowry got
Yes.
299.
Oh. 39 is adjourned, I think.
I am submitting for 35, lordship.
40 করছে. You are for 35.
35 for petitioner and he is for private party, lordship.
35, Sakshi submitted.
Tarsit submitted. So what do you want to do?
No, 35 is in the,
35 plus 40.
by mistake then. That may be taken at 2, lordship. We will go through the video, lordship, then we can confirm it. What is? Mention kone korile, ekelebole mention kori dile.
পিছত মাতি দিব তেনেহ'লে দুটা বজাত কি হয় চাই চেক কৰি লওক 39 টো কি হ'ল
My pleasure, Lordship.
39ত কোনো এপিয়াৰ কৰা নাই নেকি
39.
41.
41 case that is not received, my
What
lord.
about 39?
39, my lord, already, my lord. That case. 39 was adjourned, my lord. 39 and 40 adjourned in the morning.
That is what I said. 39 was adjourned.
Yes.
That is why he's not here. 39 adjourned হয়ে আছে।
35.
হোৱা নাই এজন 35 টো এতিয়া 2টা বজাতে কোনোবাই ফিক্স কৰি গৈছিল 41
41 Lordship. Case that is not received. I'm on interim Lordship.
alright same order enter
23/7. I'm on interim definitely consider Lordship. Obliged Lordship.
May I please, Lordship? Proceed with anticipated bail application. Lordship will find FIR as page 9, my lord.
This case that is not received, my lord, I was paid for some time, my lord.
Third time this is, my lord, may kindly see the FIR, my lord. Petitioner is not on interim, my lord. They are asking for time, my lord. Page 9, my lord, FIR is there.
Because my lord, the case that is lying before the additional sessions as Kamrup Metro, my lord. Already lying, my lord.
and we can have it on Tuesday
My lord.
alright submitted that the CD is presently lying with the additional session judge Kamrup hence place the matter again on Tuesday
44. Document 59.
My lord, Mr. Apple is in the court number 19. So please give some time, my lord.
did you receive
Did you receive my?
total yes
May I please, Lordship? Lordship, in this matter, in
Proceed subject in this case.
Lordship, but in this matter, allegation was against the petitioner in respect of daughter of respondent number 3, Lordship, not in respect of daughter of the respondent number 2 informant, Lordship.
that part is over now since charge sheet has
Now-
been submitted
Record may be called for Lordship. Both other 2 accused were granted bail, Lordship. And
already TC okay password is folder item 35 that means that CS has already been specified CS number
68/26 dated 17/6/26.
call for the TCR along with CD list আছে যদি মাতি দিও তাই
44, 59.
May I please, Lordship? My lord, petitioner is in apprehension of arrest in connection with this case, which FIR is
which one on this
my lord.
no item
Item 44,
44
daily list.
which for 59 same
State an IA.
IA
Okay. We will come on IA later. Lordship, may kindly see the allegation of the informant in this case, my lord.
yes page
19 is the vernacular and 13 is the type copy. May I read out, my lord? Sir, I would like to inform you that on 15/5/2026 at around 1 AM during performance of law and order duty at a view function organized at Chutia Gaon under the jurisdiction of Gauhati Police Station, accused person namely Sanjay Goala along with several other companions belonging to an organization ATSA were found involved in a fast fight and creating disturbance at the function venue. Around that time, I along with one APBN staff and SI Prince Borgohai were deployed at the said venue for maintenance of law and order.
During the course of day, we noticed that two groups of ARSA members were engaged in a quarrel and physical altercation with each other at the view function venue. Immediately, we intervened and attempted to stop the quarrel and restore peace and normality at the venue. Thereafter, my lord, however, during such intervention, accused Sanjay Goal and his associates became aggressive towards police personnel and started obstructing us from performing our lawful duties. They falsely alleged that police personnel had assaulted one of their ARSA companions, and on such false allegations, they surrounded us and created a tense situation at the venue. This is the core allegation. Thereafter, my lord, furthermore, the accused persons threatened me as well as SI Prince Borgoy with dire consequences. During the altercation, some of the accused persons also touched and tried to assault me, thereby creating serious apprehension regarding safety and security and breach of public peace. These are the three, second, third, and fourth paragraph is the allegation part. So, my lord, if the allegation part is considered, my lord, it is a case becomes falls under section 220 of BNS, which is obstructing public servant in discharge of public functions, which is maybe attracted. And the same is bailable, my lord.
Then
And the other sections are not applicable in this case, my lord, because neither the police personnel has been assaulted or used criminal force. So far as, my lord, allegation particularly framed against other companions, not against the present petitioner Sanjay Goala, which I have read out before your lordship at page number para 4 of the FIR, my lord. By contending the actual occurrence, one of the person, those who were present at that point of time, has also filed a counter FIR before the said police station on the next day with regard to the role of the present petitioner. So lordship will find it the same at page number 23, my lord. Page 23. Paragraph, second paragraph. In first paragraph, the said informant has also stated the same thing, but in second paragraph, he has stated that, sir, at that time, Mr. Sanjay Goala, president of ARSAB Nazira branch.
yes, PP, what is there? Any
They
material?
received the case there, my lord. The allegation is that, my lord, on the view function, my lord, there are some altercation took place between two groups, my lord. Then, my lord, the police tried to intervene and to resolve the, my lord, their dispute, my lord. Then they have accuses the police that, my lord, they have assaulted the Atsa, my lord, some Atsa leader, my lord, and they says the police personnel, my lord, and they get out the police personnel, my lord. And there are 180 testimony also recorded of the few of the witnesses, my lord. Then, my lord, they have stated that, my lord, that while trying to resolve the, my lord, dispute between the two groups, my lord, maintain law and order, my lord, they were, my lord, police were seized, my lord, and they were get out, my lord.
Okay, anyway, you have issued notice under section 35(3).
Yes,
Certified notice was issued to them, my lord, but they have not appeared, my lord.
Prima facie, you do not intend to arrest him unless there is something very serious.
Otherwise, my lord, the
If
offenses
you have
are-
it was issued notice, it is to be presumed that initially you are not. There is no sufficient ground to arrest. Only after questioning, if some ground
Notice issued,
arises,
my
you
lord.
can arrest him.
Notice, so they have not appeared, my lord.
Because that is the apprehension, they will be arrested.
And 183 also, my lord, some of the witnesses they have implicated, my lord. That these
my
are
lord,
the
I am ready to
persons, my lord.
cooperate with the investigation at any point.
Implicated in what?
My lord.
Implicated in what? Doing what?
Implicated, my lord, that only, my lord, that to extend that while they're trying to resolve the, my lord, resolve their, my lord, some altercation, my lord. Then they accuses the police person that they have assaulted one of the Atsa leader, my lord.
That is
And
not
also
an
they have
offense.
carried out the police person, my lord. And next day, my lord, they have spread also some false news, my lord, for social media.
Heard Mr. Learned Counsel for the petitioner and learned additional PP. An application under so and so. The gist of the case is that during a Bihu function being held in Gauhati from some members of the ATSA Nazira branch along with the present petitioner who is the president thereof, was present, and then altercation had taken place between two groups. When the police tried to intervene, the members of the group, including the petitioner, became aggressive towards the police, leveled allegations against the and obstructed the police from doing their duty. CDS call for has been received. Here's that a notice under section 35 within bracket 3 BNSS has also been issued. Present petitioner. Counsel for the petitioner submits that petitioner is apprehensive of arrest if he appears pursuant to such notice. Having regard to the nature of the allegations, there appears to be as well as the material available in the CD, there appears to be no clear justification for taking the petitioner into custody. Event of his appearance, the IO, accordingly. Prayer for pre-arrest bail is allowed. That the petitioner, event of his arrest in connection with ransom. So here it is. The direction here before the IO within a period of 10 days from today.
I am, my lord.
Within the IA,
Not be able to warrant issue.
Due to violation of section 35(6) of BNSS. Actually, kindly turn to page 17, 17. Party portion. There are indicating 5 notices against the present petitioner, but among them 3 were not named in the name of the present accused person, and 2 were named, but he directly not received, nor so. Considering these aspects, that as the name of the present petitioner is appeared in the said notice on the prayer of the IO, this warrant of arrest has been issued against the present petitioner by the learned concerned jurisdictional magistrate.
the heard learned counsel for the petitioner. This IA has and learned additional PP. The instant IA has been referred. Seeking to set aside the order dated 29/5/26.
One officer, my lord, the setting aside, my lord, in this bail application, that cannot be, my lord.
This is not a
Setting
bail
aside-
application.
The IA, my lord. They file an IA, my lord.
Different type of order in the
This is a
police case order.
Connection with the same case, my lord. They are praying for setting aside, my lord. For setting aside, my lord, they have to file some criminal petition, my lord.
As I have been granted interim protection, PRS bail in this case. So if these orders have been come into operation, then this order granted by this honorable court would become ineffective. Maybe.
That will be multiplicity. If you insist on that, it will be multiplicity of litigation again.
Because Lordship may kindly see at page 16, last paragraph. It's pertinent to mention that no order of anticipated bail.
No, there is
order
no
having-
necessity of, we are not going for setting aside or anything. We will simply say that he is covered by this.
Be of the order passed
That
in.
can be, my lord, but again, setting aside, my lord, they have to file separate application.
Be of the order
I
passed.
have an order
This
dated
order-
29 passed by the learned SDJM Nazira, whereby NBW was issued against the petitioner in connection with. So, what is this PS case? LAK PS case number 15 of 26. By order passed today, that is 1916 AB 1238 of
1238.
26, the petitioner has been granted arrest bail, which would be applicable vis-a-vis the order dated 29/5/2026, as well as the NBWA issued pursuant thereto. Hence, no further order is required to be passed in the present IA, which stands closed.
Published.
Negative 10.
But on 29/5/2026, the present petitioner was supervising the work in his pedophilia lordship, and the husband of the present informant, he was throwing some garbage and litters on his pedophilia, and the present petitioner objected lordship. And in fact, the husband of the informant, Zakir Hussain, assaulted the present petitioner lordship. Resultantly, he fell down lordship, and he was taken for medical attendance lordship, and he has a history of some neurological disease lordship. We have annexed those documents also. But in the meantime, while he was being given the medical treatment lordship, the present informant with the concocted story filed his present case lordship. There was in fact no land dispute as stated in the FIR lordship. And as because the allegations in the FIR appears to be very serious lordship, he is being charged lordship. But in fact, the present husband of the present informant, he was not admitted at any point of time in ICU lordship. We have from the side of the present.
Let the case diary along with the medical report be called forward.
This is what for motion.
For motion lordship, but I'm seeking interim because the keeping in view the medical condition of the present petitioner lordship. He is having a history of neurological disease. We have annexed the documents lordship at page 17, annexed to Colley. Since 2024, he is under treatment, and now also lordship he is under treatment. We have annexed the documents. As because his condition is very critical, he is not able to show on the affidavit also. On his behalf, his cousin brother has shown the affidavit lordship. So, keeping in view his medical condition lordship, at least the interim protection may be granted lordship. And the husband and the informant at no point of time he was admitted in ICU lordship. We have categorically stated he was admitted in a general ward, in fact in the conference hall of a hospital lordship. That is the statement on oath lordship. All the medical reports, if come, then everything will be clear lordship. Our FIR was unfortunately not accepted by the police lordship.
The report they have annexed, Mano, that is pursuant to year 2024.
No, there is subsequent new medical documents are also there. 12/6/2026 is the latest, and annex page 21 is a 35/2026. The only 2024 we have annexed show the history of his previous disease lordship. That's treatment is still continuing also. Only on medical ground lordship, interim protection lordship.
That is the medical. What is the actual medical problem that we are not able to find out?
It is
Your
written-
sickness certificate says hypertension and dizziness and
and
low back
low
pain.
low back pain.
That is
back
the
pain,
latest one.
latest
It
one.
doesn't indicate any neurological problem.
Neurological problem is there in 2024, Lordship. We are still
Then-
under treatment, Lordship.
We are in 2026 now.
Treatment is is continued, Lordship.
That is what it shows. Later, your own certificate shows there is
No,
nothing.
but the lower back, because of the injury, Lordship. That
Lower back pain? You don't have lower back pain?
No, Lordship. Because of the injury sustained on that day, Lordship. Because he has practically suffered injury on that day, Lordship. 29/5, Lordship. He has been advised to take rest also. Lordship.
Offenses appears to be, as stated in the affair, appears to be quite serious.
The allegations are serious, Lordship. I'm not on that, Lordship, but only on medical count, Lordship. There are certain other medical documents also will put it on record, Lordship. All the history, Lordship, previous history till today, Lordship. The treatment is continued, Lordship. But the husband of the present informant, he was never admitted in ICU, Lordship. We have stated in the paragraph, Lordship.
That case I will repeat, my lord.
Only on medical
admitted in
ground,
ICU.
Lordship. The limited prayer, Lordship. With all respect, Lordship. In fact, the husband of the present informant, he was kept in a conference room of Dorika Hospital, Tezpur, Lordship. Just giving some indoor, as a treatment is an indoor patient. Lordship. Don't have the documentary materials to substantiate that, Lordship, but that is the fact, Lordship. In fact, we sustained injury, Lordship. But unfortunately, our FIR was not accepted. We have stated, Lordship.
Heard the learned counsel, the petitioner, read it. This is an application on the switch. The allegations as stated in the FIR pertain to assault, causing of previous injuries on the victim by the petitioner. It is submitted that the contents of the FIR are exaggerated and such injury has been suffered by the petitioner. An additional PP submits that the injuries can only be ascertained upon receipt of the CD along with medical report. Hence, call for the CD along with medical report. Is submitted that the petitioner is suffering from neurological diseases since 2024, because of which has not been able to swear the affidavit of the present case. Shown by his cousin brother. Legal certificate has also been annexed, advising 3 weeks rest. Having regard to the above, it is provided in the interim that the petitioner in the event of his shall be released. 50,000. It's provided that the cooperate with the investigation. It's taken on. Swenson.
27, man, 20.
Can it be a little later, Lordship? 24, if possible, Lordship.
July.
24/7.
July.
24.
24/7, July.
Yes. I'm a blessing.
24. 24.
Did you find it?
PM report, Lordship, receipt, but cause of death opinion is regarding cause of death is kept pending till receipt of chemical examiner's report, Lordship. And Lordship, ligature mark, an oblique non-continuous ligature mark prominent mostly over back and chin is present high up in the neck. The only thing is I want to point it out, Lordship. That state is present around the vagina. That was sent for FSA, that is not yet. From last stains are there. His victim was minor, Lordship, 17 years, 10 months old.
The allegation as reflected in the FIR is that about 6 months prior to lodging of the FIR, the victim, who is aged about 17 years, 10 months, was aged about 17, loved with the accused petitioner, and he was staying with the petitioner as his wife. On 5/04/26, during morning hours, the accused allegedly caused the death of the victim by strangulation, and thereafter attempted to portray the incident as a case of suicide committed by the victim. Where the CD, along with medical report called for, has been received. Final, as per the medical report, final regarding cause of death has been kept pending due to non-receipt of report from FSL, report of viscera examination from FSL. Full stop. However, from the postmortem report, appears that a non-continuous ligature mark, public non-continuous ligature mark, was found high up on the neck of the victim, above the hyoid bone. Is primarily indicative of suicidal hanging. Having regard to the above, as well as the period of detention of 75 days, further detention of the petition. Therefore, bail is allowed. 50,000 to sureties. Culprit with the investigation shall not attempt to.
Ending 34.
Yes, dear Lordship. Lordship, pre-arrest bail petition. Petitioners are on interim bail. Lordship, kindly have a look at the Azaharet.
My lord, we have, in this case, we have received the case diary, my lord. And my lord, up-to-date case diary was also called for, my lord. We have received the up-to-date case diary also, in fact, my lord. But my lord, this statement of the accused person, they are not available in the case diary, my lord.
How is it up to date?
That is why, my lord, they have sent it, my lord, up-to-date, my lord, but it is not there, my lord.
Then whether you appeared or not?
I have appeared, I have also made a complaint. Are you not willing to record the statement? We have made a complaint to the SP, Lordship concerned Dubli district. Lordship, kindly have a look. That was received on 24/4/2026. Several location we approached to the IO, but he did not record our statement.
Otherwise, what is there in the CD?
Otherwise, my lord, there are some allegations against them, my lord, regarding forgery, my lord, of the NOC, my lord. So I maybe granted some time, my lord. Let the matter come up on Tuesday, my lord.
Learned in the council, learned council for the learned edition LPP submits that although the updated CD is available, the statements of the petitioner are not available therein. Learned counsel for the petitioner submits that pursuant to interim protection granted by this court, the petitioner approached the IC Nayahat outpost, Bilasipara PS, and also the OC Bilasipara PS for acceptance of their bail bond, but no response was forthcoming. First, in this regard, the petitioners have also submitted dated 24/04/20 before the Superintendent of Police, copy of which has been furnished to the court and kept on record. Public prosecutor takes some obtain instructions on this issue. Interim order is dated what?
Interim order dated, my lord, 7/4 months.
10 for Lordship.
There is no direction for appearance.
The case diary, my lord, once.
Hmm?
Go to the case diary, my lord, regarding the materials collected during investigation.
We can direct them even now. We can pass the direction now also for them to appear.
That can be done, my lord.
Having regard to the above, it is directed that the petitioners shall appear before the IO within a period of 10 days day for recording of their statements. The event of such appearance, the IO cell, the needful, the OC Bilasipara PS is directed to ensure compliance, ensure that the statement of the petitioner recorded in the event of their appearance. Send back the CD, which is to be resubmitted on the next date fixed. Updating the same. List the matter again. Let it come after vacation then.
22/7 months.
Interim order passed earlier to continue.
Lordship, can it be on 28? Like,
MB 57.
Please, your lordship.
Yes.
This is a criminal petition section under FOF BNSS lordship against the enhancement of maintenance amount by lord. Lord, here the petitioner is the husband of the respondent number 1 and the respondent number 2 is the son of the petitioner lordship. Just here the marriage was solemnized on 14 to 2012, my lord. And thereafter the respondent number 1, with his wife, left the matrimonial home at 29/11/2013 after 1 year lordship. So thereafter on 2014 lordship, one boy child was born lordship. So thereafter the respondent number 1, the wife, in the year 2015, sent one pleader advocate notice to the petitioner for restituting the conjugal life lordship. Lordship, in thereafter the respondent number was L1 CR case for street on property lordship. After receiving the street on property, the respondent number 1 withdraw that case, my lord. My lord, thereafter on 2015, the maintenance case was filed, lordship, under section 125 of CRPC, my lord. In that case, the honorable trial court.
Where is the order of the session judge?
Session judge, my lord. At page 139, lordship.
You are for the wife or the?
I'm for the
wife, my lord. I'm the wife and the child, my lord.
Since the
So it was reduced.
It has been reduced to 1,000 has been, it was 6,000, my lord. Session judge reduced it to 5,000. In thereafter they have again come, my lord. It is very less amount, my lord. My lord, the wife, my lord, she had to leave her husband because she was compelled, my lord. They have annexed 7 series, my lord, page number 61, where she said that she was tortured, for which she was compelled to leave her husband, my lord.
So what is the gross illegality in this order?
my lord,
You have already exhausted your revision,
lordship.
where some leniency was shown to you,
Lordship.
and you have again come. I think we are going to dismiss this with cost.
Lordship.
And my lord, for many months they have not paid my lord maintenance amount, my lord. So recently we have filed a petition under section 125(3), my lord.
That regard, we have no instruction, my lord.
And
5,000 for wife and child. Against that, you waste the time of the court. Third, learned counsel for the petitioner and learned counsel for the full respondent. Criminal petition has been referred, challenging and ordered, dated. Little second and third, okay. Second, dated. Passenger's order, okay. 2725. Appears that clearly the present respondent stroke wife had approached the learned magistrate under section 125 CRPC seeking maintenance for herself and her child and was granted an amount of originally what was the amount granted? 2015.
89. It was 2500, lordship. Today respondent number 1. And respondent number 2 for 1000, lordship.
And maintenance amount of rupees 22,500 and rupees 1,000 for the wife and the child respectively was granted. Subsequently, the respondent wife once again approached the magistrate under section 127 CRPC for enhancement of the maintenance amount, and the learned SDJ M. Bozali Pachala on appreciating the fact that since 9 years have elapsed from the date of date when maintenance was last granted, there has definitely been a change of circumstances and accordingly deemed it fit to grant maintenance. How much was granted by SDJM?
2,500 for the wife and 1,000 for the son.
No, after second time.
After it was 6,000. It was 3,000 for the wife and 3,000 for the son.
Child.
Okay, on maintenance of rupees 3,000 for the wife and 3,000 for the child, totaling rupees 6,000. The petitioner herein challenged the aforesaid order by way of criminal revision number 13 of 2023 before the learned session judge Bozali by order dated 02/07/2025. The petition was partly allowed by reducing the maintenance amount to rupees 3,000 for the wife and 2,000 for the child, totaling rupees 5,000. Was on perusal of the impugned judgments, it appears that the impugned that by way of the impugned order, the learned session judge relief, partial relief was granted, already granted to the petitioner by reducing the total maintenance amount by rupees 1,000. Stop. However, not being satisfied by that, the petitioner has filed the instant criminal petition challenging the grant of even the reduced amount of maintenance of rupees 5,000, which in any view of the matter cannot be regarded as excessive for the purpose of maintaining a woman and her child. Full stop. Therefore, it appears that the present criminal petition is an absolutely frivolous one, which deserves to be dismissed at the threshold, which I accordingly do. And further, court finds it fit to impose a cost of rupees 5,000 on the petitioner paid to the wife. It's dismissed accordingly.
Lordship, cost part may be not imposed, Lordship. Cost may not be imposed, Lordship.
Who is going to pay his fees? They have dragged her unnecessarily for this reason. Sorry, we are going to take a very tough stand on this.
Lordship.
Small amount, you are flooding the High Court with these kinds of frivolous petitions. 3,000 rupees, 4,000 rupees. For that, you come to the High Court. You have money to come to the High Court. For this, you don't have money to pay.
Everyone.
May it please your lordship.
Yes.
My lord, in the morning, lordship had kindly indulged us in this matter. My lord, senior counsel Mr. A.M. Bora, assisted by my learned brother here, Y. Chaturvedi, my lord, matter was moved. Primarily, my lord, it has come up for orders, and we are the new set of counsels. My lord, the TCR as reflected has already come. My lord, service, I believe, is awaited. However, my lord, the entire trial proceedings which are under challenge, my lord, PRC 2092 already stayed, my lord. Page number 85 is the order. That may be reflected here, my lord. That is a humble prayer. Page 85 of our petition, my lord. Page 86, last para, my lord.
But if it is already stayed, what is required to be stayed?
That, my lord, for the prime accused, it was stayed. The entire proceeding is stayed because, my lord, both the matters are not yet tagged, my lord. That observation, my lord, we are humbly praying that that may be made into present. That the matter is already stayed, my lord. And await for service.
So this is a petition on behalf of another petition.
Another petition, my lord. For the prime accused, it has already been stayed, my lord. Precisely, my lord.
Right, heard Mr. So-and-so. Counsel for the petitioner and additional PP. Correspondence. No answer of notice in respect of respondent number 2 has been received back with postal remarks, quote, addressee left RTS, unquote. However, service report has not been received back from the district magistrate Kamrup. In view of the above, petitioner is directed to take fresh steps on the respondent number 2 after ascertaining the proper address Here as called for is received. PCR is here.
My lord.
It appears that this code by order dated 04/12/2024 passed in criminal petition 629 of 2024 and state further proceedings in PRC case number 2092 of 2024 pending in the court of the learned CJM Kamrup M until further order. Much only, what else are we required to all process? It is not in respect of any
Even that
particular
stay is
petition.
there, that observation lordship has already made, my lord.
Let's list the matter again on.
Deeply obliged, my lord.
Lordship, services awaited upon respondent to
Who is the petitioner in this case?
Lordship.
Vikas
Yes,
Talukdar.
yes, Lordship.
Original record has come. Why was the original record necessary? Scan copy would have done.
Yes,
Because it is stayed only in respect of this present petitioner.
present petitioner.
And the trial court is facing difficulty in proceeding against the other accused in the absence of the original. At the stage of framing of charge, they cannot proceed without the original documents. So I think we'll send back the records after keeping a copy. Third, learned counsel for the petitioner and learned additional public prosecutor. As per office note dated 16/6/26, neither AD card nor unserved notice in respect of respondent number 2 has been received back. Hence, await service perused the letter from the Chief Judicial Magistrate Golaghat, wherein it is stated that the trial court is facing difficulty in proceeding against the remaining accused persons in the absence of the original records which were called for by the High Court and is presently tagged with the present case. Full stop. In order, since the trial has been stayed only in respect of the present petitioner Sri Bikas Talukdar. And by order dated 10/5/24, the learned trial court was directed to proceed with the trial against the remaining accused persons. The original LCR is required to be sent back. Accordingly, the registry is directed to send back the original PCR after keeping a scanned copy of the same. This is the matter again on bench.
There is an interim order also.
Interim order passed earlier to continue. Next.
47.
Please, Elizabeth. This matter is filed against the questioning of a FIR filed by the respondent number 2. It was registered 5/2/2025 is on page number 9 to 14.
You are required to take fresh steps.
Steps.
That was the last order. Because earlier address is not correct. Insufficient address.
What is it? Taken steps, you know.
No, you have not. When have you taken steps?
Was on
As per office note dated 16/6, you have not taken steps. Third learned counsel for the petitioner, Mr. Sanchev. Learned additional PP is also present. By order dated 3/6/2026, petitioner was directed to take fresh steps under respondent number 2 after ascertaining the correct address, as the earlier notice was returned unserved due to insufficient address.
May I add someone? Actually, the respondent was stayed in my rented house. Now their address is not.
That we don't know. As per office note dated In 626, no fresh steps has been taken for service on respondent number 2. What is your submission? You don't know.
We have to find it out.
That was the order, last order. That is directed to take fresh steps by speed post AD after ascertaining the correct address. And on.
Obliged.
48.
I plead your lordship. Second phase step upon respondent number 2 for the district magistrate Borpata.
Yes, what is your submission?
My lord, kindly fix the matter after vacation.
Learned counsel for the petitioner. Appears from office note dated 15/6/26 that notices were issued to the respondent number 2 by usual process on that date. And save it service list again after.
Services awaited on 16th.
Learned counsel for the petitioner, neither AD card nor unserved notice in respect of respondent number 2 has been received back. As per office note dated 16/6/26. Since the notices were last issued on 5/2/26, that is directed to take fresh steps by speed post AD. You take fresh steps, speed post AD.
Lordship, kindly fix the date. My lord, as per office note date 16/6 in respect of respondent number 2, the service report is awaited.
Learned counsel for petitioner, as per office note dated 16/6/20, service report on respondent number 2 is awaited. Just again on.
My lord, interim order passed. On
Please, Your Lordship. Lordship, a service awaited. Lordship may call for the speed post tracking record from rest.
Your wife is living separately now.
Living separately.
You don't know her address.
Address is known to me. I have sent her the notice. Whether it is received or not, I don't know, Lordship. That's why tracking report will reveal this, Lordship. I have sent it in speed post, so tracking report may be called for. They are separated in 1989 or something, Lordship.
When was it taken? Step?
It was taken, Lordship.
Which was issued on 30/05.
(26/5), Lordship. Step was taken 26/5 by speed post and Talabana.
Alternate counsel for the petitioner as per office note. These were issued on 30/05/26 by speed post as well as through district magistrate. But neither ID card nor unserved notice or any service report has been received back. Registry may obtain the consignment report from the post office. List again on after vacation.
7/7.
Lordship.
54.
Please, Your Lordship. Lordship, service upon respondent number 1 has been taken through speed post as well as through district magistrate Nalbari, Your Lordship. The same is awaited, Your Lordship. And with regard to respondent number 2, Your Lordship, neither ID card nor unserved notice has been received back. So at this stage, Your Lordship, I may be allowed to take dusty upon respondent number 2, Your Lordship.
What about 1? You were supposed to obtain proper address, I think.
We have already taken, Your Lordship. Same is awaited, Your Lordship.
Third learned counsel for the petitioner. Service on respondent number 1 is awaited as per office note. Praise for effecting dusty service on the respondent number 2. Prayer is allowed. Petitioner to take steps by dusty service on respondent number 2 and file affidavit accordingly. List again on.
Much obliged, Your Lordship.
The Lordship, this appeal is to be argued by Senior Counsel Z. Kamar. He's on legs in court number 14.
List after vacation. List after vacation.
Oh, this is the last item.
Yes, last thing.
All right. Oh, what is this matter? 25 matter. Okay, we'll have after vacation. then. The prayer of learned counsel for the list the matter again.
Eight, seven.